She's been after Trump for years, and now she's like the second person at the DOJ. But she's with all these people. And they're playing the ref, and they say terrible things about judges. They do it with the Supreme Court justices because they think they're going to intimidate them. I think it should be illegal. That's what the DOJ should look into, the legality of these people taking a brilliant judge and demeaning her, and taking other people that are fair and solid and demeaning them. It's called playing the ref. Nobody did it better than the late, great Bobby Knight basketball coach. He would scream at those refs and everything. They'd say, Bobby, you're not going to get the decision overturned. Yep, but the next one I will. And he was right. He was a great basketball coach. Last coach to have an undefeated season. Last coach in basketball to have it many years ago. He also endorsed me, but he played the ref. These people are playing the ref when they are allowed to call for recusal, impeachment of a judge because they're not getting their way. And for some reason, the other side doesn't do that. They don't do that. The other side is much softer. Republicans play it a lot softer, but they play it legitimately. So I'm going to ask, if I might, Will Scharf to come up, just say a couple of words about what took place today. One of our attorneys working on this it's a ridiculous case. Remember, it never happened. It was made up for political reasons. And the DOJ is behind everything. Every one of these cases. It's political interference. It's a witch hunt, just like the fake Russia scam was a witch hunt. And just like they want to start that scam all over again by announcing that Russia, we're talking about. And you know what they do when they do that? They intimidate people from having a fair election. They intimidate poll workers from speaking up when they see crooked things take place in the election. And it's a disgrace. Our country's in serious trouble. Our judicial system is in very serious trouble. Will, please come up. Thank you.
Good morning, y'all. My name is Will Scharf. I'm one of President Trump's attorneys. Today, we presented oral argument before the United States Court of Appeals for the Second Circuit in one of two cases brought against President Trump by E. Jean Carroll. Now, it's really important to remember that E. Jean Carroll's story at its heart is an utterly implausible he said, she said story. There is no corroboration for anything she has ever claimed about President Trump. There are no corroborating witnesses. As President Trump alluded to, there is not confirmatory DNA. No police report was filed at the time of this alleged incident. She was unable to identify when this incident occurred until quite recently. No surveillance evidence or witnesses have ever been found or come forward confirming any aspect of E. Jean Carroll's story. In light of that, in light of the utter implausibility of the story that E. Jean Carroll was attempting to sell to the jury in this case, her attorneys introduced evidence that should have never seen the inside of a courtroom. Utterly insane efforts to introduce propensity witnesses, Jessica Leeds and Natasha Stoynoff, most notably, in an unfair and improper effort to buttress E. Jean Carroll's failed attempt to assault President Trump. Jessica Leeds' story is instructive here. This is a woman who claims that in the middle of a crowded airliner in 1979, President Trump assaulted her. Leeds has never been able to identify where this plane departed from, where it went to, the date of the flight in question, making our efforts to disprove her testimony extremely difficult. Under the federal rules of evidence, this story should have never been allowed to be presented to the jury in this case. The same is true of Natasha Stoynoff's story, which again lacks any indicia of reliability, any sort of credibility, any sort of confirmatory testimony from other witnesses, or anything else that would make you believe that this actually happened. So on the one hand, you have a judge who allowed in this improper propensity evidence that should not have been allowed in. In our view, that polluted the jury's deliberations in this case. That presented a story to the jury of a series of a pattern of conduct that the jury should not have been considering. And we think that absent that propensity evidence, no fair jury could have reached the verdict that was reached in this case. And as a result, we believe that this verdict needs to be overturned. But there's more than that. In addition to this improper propensity evidence, President Trump and his trial team were prevented from cross-examining E. Jean Carroll and other witnesses on crucial issues in particular relating to political coordination and the political motivation behind this entire lawsuit. This is a lawsuit that was instigated in large part by George Conway, a longtime political foe and adversary of President Trump. This is a lawsuit that was funded by Reid Hoffman, a key political ally of the Biden-Harris administration and a major Democrat donor. We were limited in the evidence we were allowed to present at trial about these crucial facts. We were prevented from cross-examining E. Jean Carroll on aspects of that dynamic that underlies this entire lawsuit. And that, too, unfairly corrupted the jury's deliberations in this case and requires reversal of the jury verdict. I think this political coordination point is particularly important, though. It's important to emphasize because what we have seen in the last few years is a weaponization by the Biden administration and by their political allies of our legal system and of our courts to unlawfully, unconstitutionally interfere with President Trump's core First Amendment right to run for president. That is a right guaranteed to him by the Constitution. That is the right that his political opponents are attempting to strip away from him. We have seen this in case after case after case where unfair political motives have underlay what should be serious legal proceedings. And I think when you look at this situation in toto, when you look at what the left, when you look at what the Biden-Harris administration is attempting to do to President Trump, this is insane. This is an absolute abuse of our legal system. It's an absolute abuse of the rule of law. It should be deeply offensive, not just to political supporters of President Trump, but to each and every American. With respect to today's appeal, we are hopeful that the Second Circuit understands what's at stake here. We are hopeful that the Second Circuit understands what occurred during this trial, which was an improper use of evidence to buttress E. Jean Carroll's entirely meritless claims on the one hand, and an improper exclusion of evidence that would have informed the jury about the true motivation behind this lawsuit and that we believe would have resulted in a very different verdict. Thank you.
Thank you very much.
Good afternoon. I've done this one too many times, actually too many times for the last 3.5 years while President Trump has been trying to fight to get this country back. And I want to speak to the American women, and I want to speak to the people that need to get out and vote on November 5th. I have sat with President Trump for years now, while he has been targeted with lies and with judges, AGs, and DAs who have specifically run in this city and others on getting Trump. The Trump administration will fix this problem. We will stop Kamala Harris's regime, because she was there, let's not forget that, and she still is, of using officials from the White House, putting them in DA's offices, in AG's offices, and attacking your political opponent. And this country deserves better than this. We do. We should not be sitting here at a press conference talking about this. We did this in 2016, and every woman had no reports. They come out when it's election time. And as a woman who has stood with President Trump, who has spent extensive time with President Trump and with his beautiful family, I will tell you, that is not President Trump, and I completely am disgusted by what I have seen happen to this person, his family, and the Trump organization that we stand in right now. You must vote Donald Trump back in, because as an attorney, as a woman, as a mother, our future of this country depends on it, and we need to stop this from happening. The DOJ is supposed to help our country and protect us, not attack us, because you cannot win in the polls. Thank you.
Thank you very much, both. And just in finishing this, we have numerous other trials that are also very much in coordination with the DOJ. They actually took just about their top person and they put him into the offices of the Attorney General of New York, and then also the office of the DA Bragg's office, to make sure the case is brought viciously against their political opponent. And it's a shame. It's a shame. Businesses will not come to New York because of it. They actually, in the case of Engoron, they used a consumer frauds case, never used before for a thing like this. And not only were my numbers correct, and again, this was a generality. All you need is a general, but I had really good numbers, but they were very conservative, very much on the low side. And the judge knew that. And the judge ruled a fine against me, the likes of which has never even been heard of. Businesses will never come to this state as long as that is able to be held up, because we won that trial so conclusively. We had an expert witness said that President Trump's financial, this was an expert witness from the Stern School of Business, one of the most highly respected people in the country, as an expert witness. He said, to the best of my remembering, it's a big statement, but he said, this is perhaps the best financial statement I've ever seen. But the judge made me pay like a $400 million fine. This is a consumer fraud statement. Think of it. Consumer frauds case that they made it in. The judge refused to give it over to the commercial division where they could understand things, and they would have dismissed it immediately because this case had no merit whatsoever. The judge wanted to settle the case for a very much smaller amount. And I said, I'm not going to settle. I didn't do anything wrong. But he would have settled the case for a much smaller amount. He wanted to settle it for a much more. We had numerous meetings in his office for a fraction of the number that he gave. That was one of the interesting things. I figured that the worst that you could do is what he wanted to settle for, which was a very small number by comparison. And then he just came out with this number. This was a coordination with the DOJ. And the other case that you know about and you've been hearing about, which is same kind of a thing, also in coordination, is the Bragg case. And they actually wanted to put them together in New York. They wanted to put the DA case together with the Attorney General case, but they both wanted credit. They couldn't understand, they both wanted credit, so they had their own cases. And it's very corrupt in New York, and very, very corrupt. It's a very corrupt place and doing very badly. But when people see what happened, and when they see, I've had so many calls from business people saying, this is just terrible. Today, there was a story about somebody in Southern District who's highly respected, knocking the hell out of both of those cases, say it's an embarrassment they were allowed to be brought. And I'm going to write out a list of things from Alan Dershowitz, Andrew McCarthy, Greg Jarrett, some of the greatest people, all legal scholars, great people, Jonathan Turley, like 10 highly respected, the most highly respected people that quote Calabrese, Judge Calabrese, that quote on cases, and they, shockingly, they can't even believe it. They said this case should not have been allowed to be brought, and that's about pretty much both cases, but it's about the case that we have in front of Judge Mershon. That case is a disgrace. Should have never been allowed. I did nothing wrong. And he took a non-existent, expired, long expired by the statute of limitations, misdemeanor. He made it into 34 or something more than that counts of felony. Nobody can even believe it. Over nothing. And if you look at that case, he wouldn't allow it. That whole thing was done by an attorney. I had nothing to do with it. That was done by an attorney, a sleazebag named Michael Cohen. And he did the whole thing. And you're allowed to have reliance on attorney. It's called reliance on attorney. You have a reliance on attorney. Attorney's allowed to do things. And all it was is a non-disclosure agreement with somebody that said nothing happened, by the way. I might add that. If you don't mind, I'll add that. We have a statement, nothing happened. And he got a non-disclosure agreement. He did it on his own, and this judge refused to allow us to use that as a defense, the attorney-client defense, which is very standard. Other people have never heard that you're not allowed to use it. But he's the one that did it because I was running for president and running the country. He's the one that did it. So all of these cases are a disgrace. But the case that we had today, downtown, I wish we could have mentioned the dress. Again, got the idea from Monica Lewinsky, but it was negative, wasn't allowed to be used. I wish we could have mentioned many of the other things, and I certainly wish we could have gone to CNN and got the outtakes, what's called the outtakes. What did Anderson Cooper tell her during the commercial? I'd love to find that out. So that's where we are. We have a very corrupt system of laws, but in that system we have some very good judges also, and I think in the end the good judges will prevail.